Welcome to this webinar on challenges in infrastructure arbitration. And today we have speakers like Mr. P. Srinivasa Reddy, as well as Mr. Srikanth Hariharan. They are expert in their fields, and they will be sharing their presentation as well as their ideas about challenges in infrastructure arbitration. And after that, we will have a Q&A session. In Q&A session, if you have any questions, you can ask your respective questions to the speakers. And then we will have maybe a poll to get to know about your views about infrastructures, challenges in infrastructure industry. So let's start. But before we start this session, I would also like to take you through a brief introduction about Contract Square. So I'm Abhishek Chaubey from Contract Square, and we have organized this webinar on challenges in infrastructure arbitration. The motive of this webinar is basically to educate our fellow members from the industry about importance of contract management and what kind of challenges companies face, contractors face in infrastructure in infrastructure industry, and how to go about any claims issue, or if it escalates to arbitration. This gentleman, the panel of this webinar, which is we have Mr. P. Srinivasa Reddy and Mr. Srikanth Hariharan. They will try to take you through the strategies of how to manage any infrastructure arbitration case. So before I kickstart this presentation and let the speakers speak, let me very briefly take you through our own credentials, who we are, and what Contract Square is all about. So I'll just share my slides with you so that I can show you, a bit of information or slides on Contract Square. It will be very brief. I won't brag much about what we do and who we are, but it's very important for you to know what is Contract Square. So Contract Square started with the name a few years back as eClaim Solutions, where we were providing our services to a very handful of clients in India, a very close group of clients in India. And after a very successful stint in contract management, claims management, and arbitration management industry, we decided to regroup ourselves, rebrand ourselves as Contract Square, and now we are going to the market and catering to a larger number of clients in India for contracts management, claims management, and arbitration management services. Plus, we also do provide litigation assistance as well. So we'll go to next slide. I hope you are able to see my slide. As you can see, the range of services that we provide is contracts management. I think contracts management is the very basis of any claims issue or any arbitration matters that you go into. If you manage your contract right, I think we will you will be able to have a very sustainable case in terms of arbitration. So contracts management is one of the services that we provide, and we do provide claims management services, forensic delay analysis, dispute resolution, project management, and of course insurance management as well. In contract management, we are serving a range of clients who belong to different sectors altogether. As you can see at the very bottom, we are catering to clients from railways, highways, buildings, irrigation works, power transformation. These are just a few examples. The range is quite extensive. As you can see, we have provided our claims management solution to a range of clients in India, and which is more than 1,200 crores, lot more than 1,200 crores right now, and we help them secure these claims very successfully. Dispute resolution, as I told you, we do provide, arbitration management solution. So dispute resolution is all about ADR, alternate dispute resolution, where there are different kinds of mechanism which includes negotiation, mediation, and arbitration, and we help our clients in infrastructure industry with all this range of services. Of course, document management is one of the element of the services that we provide, because for any contract management, it's very important for client to have a very robust document management system. So we do provide document management system where we do digitize their documents and digitize the documents and keep it in a very indexed way, so that whenever the need for such document arises, it is readily available with the client to prove their claims. And of course, as we go into detail, you can see that we provide insurance management services as well as insurance claim management, where we help them with evaluation of insurance portfolio, establishing insurance uh, priorities, as well as maintaining comprehensive documentation and records to file claims. Again, I've listed just a few sectors where we are catering right now. Again, the list is quite extensive, but because of confidentiality, we are unable to share the names of our clients and the range of projects that we are working on. But as you can see, we are working in roads, which is north sector, power, water supply, irrigation, and NCLT matters. Now, at the end, as you can see, this is our credential. You can see our email address. If you have any inquiries or any queries, you can reach out to us at inquiries@contractware.co. Plus, our phone number is here. And as you can see, our presence in India, we have a pan-India presence with offices in Kolkata, Delhi, Hyderabad, Mumbai, and Guwahati, and many more to come in coming months for sure. So that's a bit about us, and I'll stop here and I'll ask Srikanth Hariharan. Mr. Srikanth Hariharan is from Hariharan and Hariharan Law Offices, and I'll take you through his brief profile since we do not have much of a time. He holds a degree in Masters of Law, that is LLM, from University of Cambridge, with specialization in dispute settlement, international arbitration, and international commercial litigation. So that is Mr. Hariharan. And now I'll open the dais for Mr. Hariharan. So Mr. Hariharan, I think now it's your time. You can talk about the topic he's going to touch is timeline is the essence of arbitration. So the dais is yours.
Thank you, Abhishek. Thank you, Abhishek. Am I audible to you?
Yes, you are audible.
One second. I'll just open my presentation slides.
Right.
Are my slides visible?
Yes, it's visible now.
Thank you, Contract Square, for giving me this opportunity. I'm sure it's a Friday evening. I'll not hold you guys up for the weekend. I'll try to be as brief as possible. And I'll just directly come to the topic for today. The topic that I have been asked to speak about is timeline is the essence in arbitration. I cannot overemphasize as to the fact as to how much that we need to adhere to the timelines that are prescribed in the Arbitration and Conciliation Act. So before I proceed with the timelines, I would like to speak to you about what is the advantage or why is it important that we have a time-bound dispute resolution. Whenever there is a dispute where one party makes a claim and another party denies the claim, there are certain options that any client would want to look for. Either it can be litigation if there is no arbitration clause in the agreement, or it can be arbitration if there is an arbitration clause in the agreement, or it can also be negotiation to see and to look for an option whether this issue can be settled without going through the rigor of arbitration. Why is it so that negotiation also negotiation or this alternate dispute resolution is an important factor in any dispute resolution? Majorly, for any business, time is money. A thing which the cost of holding 1 crore rupees will not be the same of holding 1 crore rupees 5 years later. So therefore, whenever there is a dispute, it is very important for the clients to understand and do a cost benefit analysis of what is the issue at hand and what is the time frame within which this dispute is going to get settled, and whether the cost and the benefit that I would get by virtue of going for any of the dispute resolution methods, be it litigation, arbitration, mediation, or negotiation. I would not be going into the specifics of mediation and negotiation because that is for another day, and it requires a certain amount of time for to be spent on. The second of my slides is that why arbitration? Why do people choose arbitration as an alternate dispute resolution? We have been also looking in the media as to how much the court system is burdened with, whereby a suit for recovery of money, if it were not through the process of arbitration, it is taking an average time frame of 3 to 5 years at the trial stage, and at the appellate stage it is taking a time frame about again similarly 5 to 7 years, though there are cases which are older in time also, but as on an average 5 to 7 years is the time frame. So you could expect that a decree that you have is confirmed by the appellate court, that is the high court, and also by the Supreme Court if there is a special leave of appeal to the Supreme Court. The time frame is going to be about 10 to 15 years for you to have a claim crystallized against your respondent. Therefore, it is important that arbitration plays a important role in speeding up the process of dispute resolution, whereby a private adjudicator sits on the dispute and then adjudicates based on evidence of both the parties. The hearing, one of the major advantages is that there are relaxed rules of procedure and evidence before the arbitrator, as you all know, that the provisions of Civil Procedure Code and the Evidence Act are not mandatorily applicable. So therefore, that due to the relaxed rules of procedure, people do prefer the arbitration route. And more importantly, one of the advantage is that there is a quick procedure for appointment of arbitrator. If it's an institutional arbitration, the appointment is through the institution that is named. It can be Singapore International Arbitration Center or the ICA, Indian Council of Arbitration. If there is no institution that is prescribed in the agreement, then the Chief Justice or the designated judge of the High Court, if it's a domestic arbitration, and if it's an international arbitration, the Chief Justice of India or the designated Supreme Court judge has the authority to appoint the arbitrator. Usually, the courts tend to appoint sole arbitrators unless the agreement says that it's a 3-member arbitral tribunal. So therefore, the appointment procedure is also a factor, and appointment procedure is also considered to be an advantage for choosing the arbitrator. The last of the advantage is that as per the new costs regime that has by the newly amended Arbitration Act, the tribunal has the power to award costs in favor of the party that has succeeded in the arbitration. That is the reason why people try to choose arbitration, because generally in the court system, each party will have to bear its own costs. So, cost regime in the new section 31A of the Arbitration Act, which is amended, uh, provides for a situation whereby the losing party will have to pay the winning party's costs. The second, the now the, having understood the advantages of arbitration, now let us go to the practical disadvantages of what happens, why people tend not to choose an arbitration. Uh, the Again, the disadvantage is that you have a challenge to the award before the courts of law. Though there are limited grounds of challenge, again the rigor of the court system would kick in, and that the process of challenging the award before the court is also time consuming. The second of the disadvantages that under this procedure to challenge the award, the court can only decide as to whether it has to set aside the award or it has to confirm the award that is passed. The power to modify an award is not prescribed under the challenge procedure, which is section 34 of the Arbitration Act. So therefore, assuming that you have obtained an award and then in the challenge stage, the court finds that your award is not tenable in view of the grounds of challenge which satisfy the requirements of section 34, the court can only set aside the award. And if once it sets aside the award, the entire process of arbitration will have to be repeated. The it is the costs regime for the arbitration process may also be taxing for some of the clients some of the smaller companies who cannot afford the arbitration process. So therefore, that is also a procedure, that is also a disadvantage that some clients perceive of due to the arbitration. I mean, due to agreeing to an arbitration clause in the agreement. Now, coming to the main topic of discussion, that is timelines is the essence of arbitration. You would see that under Section 4 of the Arbitration Act, it is very important that if any right is conferred on you by the Arbitration Act, and the objection or the exercise of that right would have to be made within the time period prescribed under the act. If not, you would waive the right to object at a later point in time. Therefore, the time limits which are prescribed under the Arbitration Act are sacrosanct, and if no objection is taken within the time frame prescribed, the party loses the right to object at a later point in time. So therefore, it is important that the timelines prescribed by the Arbitration and Conciliation Act, are to be adhered to. For the purposes of the present presentation, I have divided the presentation into three parts. One is the timelines which the party or the client has to adhere to prior to initiation of arbitration, the timelines which have to be adhered to during the process of arbitration, and the timelines which are to be adhered to after the arbitration proceedings are over, culminating in the passing of the award. So, firstly, with regard to the timelines which are pre-arbitration, it is to be seen that the cause of action for any arbitration or claim arises once the matter or the dispute is referred to arbitration. Until that time, there is no cause for you to start the arbitration process. Under Section 21 of the Act, there is a procedure as to how arbitrations would have to be initiated, where the request for a dispute to be referred to arbitration a notice to that effect is given to the respondent or the opposite party, and the same is delivered to him. That is when the notice is received by the respondent, that is the start date for you, whereby the arbitration proceedings have been deemed to be commenced by virtue of Section 21 of the Arbitration Act. It is important to note that demand or that notice of arbitration would have to be given within 3 years of your cause of action arising. For instance, if there is a final bill issued, uh, in a construction contract, there are multiple bills that are raised and the payments are made. It is not to say that the first bill you raise and 3 years begins from that day. It is to say that when the final bill is submitted to the, say, principal employer for payment, the date of submission of the final bill becomes the cause of action for you to initiate arbitration if no payments have come within the period of 3 years. So therefore, for example, if the final bill was submitted on 5/1/2020, you have a cause of action to initiate arbitration subject to the agreement between the parties containing an arbitration clause within the period of 3 years. That is, your limitation period expires within by 5/1/2023. So therefore, before 5/1/2023, you will have to issue a notice of arbitration to the other party claiming your amounts. Now you would have issued the notice of arbitration within the period of 3 years. Suppose the agreement provides for a procedure for appointment of arbitrator. There will be no difficulty if it's an institutional arbitration. The concerned institution will nominate the arbitrator. But if there is no agreement to that effect, then, as I said, the Chief Justice of the concerned state, if it's a domestic arbitration, or if it's an international arbitration, the Chief Justice of India or his designate Supreme Court judge will appoint the arbitrator. So that application under Section 11 seeking appointment of an arbitrator would also have to be made with after 30 days of issuance of the notice, but before the 3 years from the date of notice under Section 21. So suppose if you had issued the notice on say 1/1/2023, submitting the claim to arbitration, you would have to seek appointment of the arbitrator within 3 years. That is before 1/1/2026. That would be the time frame within which you would have to seek appointment of the arbitrator. Now, it is very important to know that the period that is mentioned in the slide, that is 15/3/2020 till 22/10/2021, has been excluded for the purposes of commutation of the period of limitation. This is because of the COVID-19 pandemic. There has been a relief that is given by the Honorable Supreme Court that this period will have to be excluded for the purposes of commutation of the period of limitation. During the the basic point pre-arbitration is that you'll have to ensure that the timeline of 3 years from the date of cause of action is maintained. That is the sacrosanct red line for pre-arbitration step. During the going further, during the process of arbitration, during the process of arbitration, once the tribunal is constituted, there is once the tribunal is constituted, it is time for filing of the claim statement and the statement of defense. The arbitral tribunal will fix a time schedule as to the period within which the claim statement has to be filed, the defense statement has to be filed, and the inspection of documents by either of the parties is carried out within a time frame. that schedule is also quite sacrosanct for the reason that if the schedule to the schedule as suggested by the tribunal or as ordered by the tribunal is not adhered to, that will have an impact at the time of hearing when costs are decided. If one of the party has been unduly delaying the process in filing the claim statement or filing of the written statement or production of evidence before the tribunal, the tribunal has the power to regulate the issue of cost by awarding the costs in favor of the party against the party who has unduly delayed the process of arbitration. And that is with respect to fixing of a timeline for filing of the claim statement, defense statement. Usually, depending on the claim that is or the nature of the claim, 4 to 8 weeks is a general process whereby parties are given time to file the claim statement, and an equal amount of time is also given to the respondent to file their written statement or the defense statement of defense within a further period of 4 to 8 weeks. So that is with regard to filing of the claim statement and defense statement. Now, this is very important. This is a very important step in the arbitration process, and it is important that any objection to the independence and impartiality of the arbitrator, to the person of the arbitrator who's sitting in the tribunal, is challenged within a time frame. Section 13.2, as it is reflected in the slide, within 15 days of constitution of the tribunal, or you or the party becoming aware of the justifiable doubts with regard to the independence and impartiality of the arbitrator, can raise the issue before the same arbitrator, and it is incumbent on the arbitrator to decide the same and issue an order to that effect. You would see that on the slide, the seventh schedule and fifth schedule are mentioned. It is important to note that the grounds of challenge to the impartiality of the arbitrator, if they fall under the grounds mentioned in seventh schedule, it can be raised at any stage of the arbitration process, because that goes to the root of the matter. One of the ground that is there in seventh schedule is with respect to where the arbitrator has acted as a advocate or client, or was a client to the one of the parties to the dispute. So the provision says that if it's a ground of challenge which falls under seventh schedule, despite any agreement or consent by either of the parties, the arbitrator stands disqualified. In the grounds mentioned in fifth schedule, it is incumbent on either of the parties to raise the ground as a challenge to the impartiality or independence of the arbitrator before the arbitrator within 15 days. And second, thereafter, during the arbitration process, it is not like a court process whereby adjournments are granted at the drop of the hat. The adjournments would have to be reasoned, and generally the proviso says that there should be day-to-day hearing. Day-to-day hearing doesn't mean that Monday they sit and Tuesday they sit. The hearing means when the pleadings are completed and the matters have come up for argument, then the issue of day-to-day hearing comes, and the tribunal also has a discretion to adjourn the matter depending on, because there are cases where adjournments are necessary, where especially there is some personal exigency of the client or of the authorized signatory or of the counsel, or there is a bereavement in the family of either of the parties or the arbitrator, there is some health issue. On those are justifiable grounds for grant of adjournment, but then the adjournments would have to be on the basis that they are a solid reasoning for why the adjournments are being granted. And obviously, as I earlier reiterate, as I earlier said, and I reiterate, if there is a party who is seeking adjournments unnecessarily, the arbitrator has the power to control the party by imposing appropriate costs which compensate the party who is wrong. So that is the timelines or process which are important during the arbitration process. Now, what is the default? What is the remedy for not adhering to the timelines as prescribed by the arbitrator or as prescribed under the act? If there is a default with regard to adhering to the timeline, Section 25 says that if it is a claimant who is prolonging the matter, the claimant, the arbitrator has the or the tribunal has the power to terminate the arbitration proceeding. And if the respondent is delaying the process, then his right of filing of the defense will be forfeited. So therefore, I cannot overemphasize as to the fact as to how much it is necessary that the timelines as regards the arbitration when the arbitration proceedings are in progress will have to be adhered to. Now, coming to these next of the slides, this is very important because this is the amendment that was carried out to the Arbitration and Conciliation Act. It's the Section 29A says that the award has to be passed within a period of 12 months from the date of completion of the pleadings. That is, when the claim statement is filed and the statement of defense is also submitted to the arbitral tribunal, irrespective of what is the completion of the date for trial or production of documents, the award would have to be passed within a period of 12 months from the date of completion of the pleadings. If the, in fact, Section 29A also provides a benefit for the arbitral tribunal if it pronounces the award within 6 months of reference. Reference is when the High Court or the Supreme Court refers the matter to the concerned arbitral tribunal. They are entitled to additional fees if they pronounce the award within 6 months. This time period of you would have seen that 12 months is the period by which award would have to be passed from the date of completion of pleadings. Now, by consent, there may be it is quite possible that the award could not be passed within a period of 6 months. By consent, the time period can be extended, but it cannot be extended for a period beyond 6 months. And the period can also be extended by the court, but there must be solid reasoning as to why such an extension is sought for. And an application to that effect would have to be made. If it's a domestic arbitration, it has to be made before the district court, concerned district court. And if it's a commercial court, it has to be, if it's a commercial dispute under the Commercial Courts Act, the application would have to be made before the concerned commercial court. And if it's an international arbitration, the extension of time, that is the application under Section 29A, would have to be made before the concerned High Court. Then the timeline of 12 months and 6 months having been expired, and if the arbitrator still does not pass the award, the arbitral tribunal and the delay should be attributable to the arbitral tribunal, and the parties are entitled to maximum extent of 5% of the refund of fees that is paid by the parties for each month's delay. So this is a very important aspect whereby there is a consequence that is attached for not adhering to the timeline. Now the arbitrator passes the award. This is with respect to say the procedure, as I said, that the procedure of issuing the notice, the procedure of appointment of arbitrator by the Chief Justice, and the leading of evidence, filing of claim statement during the arbitration process, and the time limit for passing of the award may seem to be cumbersome for some of the parties, and the parties can agree that they agree for a fast track procedure. There may be cases where the disputes are borne out by record and there is no further evidence to be led. So generally in construction contracts, unless there are serious disputed questions of fact, there are agreements and there is correspondence between the parties, and the correspondence reflects the intention of the parties also. So therefore, the parties can also agree on a fast track procedure whereby the claim statement and with documents and the written statement with documents are filed before the tribunal, and the tribunal considers that the matter can be disposed of based on the oral evidence, based on the documentary evidence led by the parties. The tribunal can pass the award based on the pleadings and documents that have been submitted by the parties. This has to be done if if a fast track procedure is adopted, then it has to be completed within a period of, as it is seen in the slide, 6 months from the date of reference. Now we have come to the stage whereby the award is passed and parties are having a look at the award. Within 30 days of receipt of the award, if there is any correction or if there are any doubts as to the interpretation of the award, parties can make a request to the arbitrator within 30 days to the arbitral tribunal to either clarify or correct the mistakes that have been pointed out by either of the parties. This has to be, the tribunal can also suo moto within 30 days make corrections to the award. The tribunal can also, the parties can also request for an additional award within a period of 30 days. The additional award would have to be passed within 60 days from such request being made by either of the parties. This is a very important, now that the award is passed and you have the award in your hand. What is to be done with the award? Either you can comply with it or you can challenge the award. The issue comes when the parties have decided to challenge the award. The challenge to the award is under Section 34 of the Act, and the challenge to the the Section 34 pertains to domestic arbitration or international arbitration held in India. So therefore, any challenge to the award for an arbitration award passed in India, Section 34 is applicable. The time limit prescribed is 3 months from the date of receipt of the award. That is 3 months from the date of receipt that the party receives the award. There may be cases that you were set one of the parties was set ex parte during the award, and you were set suppose if you are the person who is challenging the award and you receive the award on say 6th January 2023, you will have 3 months time from this date to challenge the award before the appropriate court. As I said again, if it's a commercial court, before the if it's a commercial dispute, before the commercial court, and if it's an international arbitration, then it has to be challenged before the concerned high court, because the place of arbitration is in India. So within 90 days, the award would have to be challenged. The proviso to Section 34(3) also gives an extension period, if you can say, for 30 days if sufficient cause is shown as to why the award could not be challenged within the period of 3 months. It is very important that there must be a sufficient cause that is shown. The plausible reasons that I had already discussed is with regard to health reasons or personal exigencies or emergencies. That period of 30 days, that extension period of 30 days where sufficient cause to be shown is important, because after 120 days from the date of receipt of the award, no challenge is permitted. That 120 days is the sacrosanct period at Lakshman Rekha, if you can call it, after which no challenge to the award is permitted before any court of law. From that date, after the expiry of period of 120 days, if the award is not challenged, the award becomes a executable decree. It's executable as a decree of a civil court. Now, with regard to international arbitration, it is very important that if the place of arbitration is outside India, if the place of arbitration is in India, I have already said that the challenge should be in the concerned court in India or concerned high court in India, wherever the place of arbitration was. So suppose if the place of arbitration was in Hyderabad, the High Court at Hyderabad. If it was in Bombay, then the Bombay High Court would have the concerned jurisdiction to entertain a challenge to the award. Now, with regard to awards or foreign awards which have been passed in, say, Singapore or London or Dubai, the challenge should be as per the local laws. Suppose, for instance, in Singapore, as per the Singapore Arbitration Act, under their section 48 of the Singapore Arbitration Act, the time period prescribed is 3 months from the date of receipt of the award. So you would have to challenge the uh, award, a Singapore seated arbitral award, before the concerned court at Singapore within 3 months from the date of receipt of the award. If it's a London arbitration award, say if it's an arbitration award passed by LCIA, then under the UK Arbitration Act of 1996, under Section 70 of their Act, the award would have to be challenged within 28 days of the date of the award, irrespective of when the award was received by the party. So if you can see the difference between the two, you would realize that the date of receipt and date of receipt of the award and the date of the award. So therefore, it is very important to keep in mind the relevant date as on which the date of award was passed. Now the third the once the after the challenge to the award, the as I said, the court can either agree to the award or may set aside the award. If the award is confirmed, then it becomes an executable decree. If it's a domestic arbitration, since it's an executable decree, the under Article 136 of the Limitation Act applies, and the award would have to be executed within a period of 12 years from the date where the final court proceedings have ended. Or if there was no stay to the award, suppose if you have challenged the award and there was no stay granted by the court under 36 under the Arbitration Act, if no stay is granted by the court or the High Court, the award becomes immediately executable. So if an award is passed today and there is no stay by any court, though there is a pending challenge under Section 34, the award would still have to be executed within a period of 12 years from the date of the award. So you would have time till 2035 for execution of an award which is passed today. Now, with respect to that is with respect to a domestic arbitration, but with respect to an international arbitration, you would see that the limitation period is not 12 years. It is 3 years from the date of the award, or where the challenge, if there is a challenge, say before the Singapore court, and there is no stay for the award there, then the challenge would have, then the award is executable only within a period of 3 years from the date of the award. Though you can file multiple execution petitions, the first of the execution petition would have to be filed within a period of 3 years. Similarly, for domestic awards, the first of the execution petitions would have to be filed within a period of 12 years. So therefore, this is 12 years for domestic award, and international arbitration awards 3 years is very important, and it has to be kept in mind before any strategy is worked out. What are the practical considerations that have to be taken care of uh, having a dispute resolution strategy? And timelines is one of the aspects that we would have to keep in mind. while we discuss any dispute resolution strategy to be adopted, because ultimately as businesses, it is the objective to see which of the dispute resolution strategy to be adopted, so that the matter can be either settled, or the matter can be effectively adjudicated where your rights are protected. And it is uh, it is very important that the parties are vigilant of the timelines, because being vigilant of the timelines is also being vigilant of the rights that are guaranteed under law, and law protects only those people who are vigilant. It is very important for any party to consult an in-house legal counsel on the timelines, as well as on critical matters. Say whether the claim is time barred, or do we need to raise a claim today, or do we need to approach the court, or say, as I said, once the award is passed, parties may be negotiating for a settlement. But it is important to note that the negotiation process will not extend the time frame. So if parties are negotiating for a settlement, it is important to note that you are before the court, uh, availing your remedies, so that later, if settlement talks fail, you are not left remediless. It is also important to note that parties ensure the correspondence between them is in accordance with the terms of the contract. As contract is the governing document, or the constitutional document for the relationship between the parties, contract is supreme between the parties. All correspondence and all rights flow from the contract. All correspondence would have to be in accordance with the contract between the parties. As I as I pointed out, cost cost benefit analysis is very essential to ensure that the litigation or the arbitration strategy that is being adopted by the parties is in accordance with the cost benefit analysis, which also includes the subsequent judge risk, or the merits of or demerits of the case itself. That concludes my presentation. If you have any questions, I would be willing to answer them if I find them in the Q&A portal.
Thank you, Mr. Hariharan. I think it was quite informative and quite insightful when it comes to arbitration and how important the timeline in arbitration is. And as you have rightly concluded, law protects only those who are vigilant. And it's very important. I mean, there are 4, 5 points which you have highlighted. And the
Hmm.
second one is the legal, consulting the legal consultant or a lawyer is in critical matter is very important. And the correspondence between the parties and the right way of corresponding is something which people should look at. And as you rightly said, contract is supreme between the parties. So contract is very important and very supreme between the parties. And lastly, uh, the cost benefit analysis, whether it's right, whether it's prudent to go for for litigation or not. It's very important that you can do by cost benefit analysis. So now I would request our attendees, if they have any questions, please put forward your questions right now so that it can be answered by the panelists here, by Mr. Hariharan. I think there's one question
Yeah.
regarding the timelines in pre-arbitration stage. Please elaborate on the cause of action. Any other examples other than final bill?
Uh, uh, Abhishek, am I audible?
Yes, now you're audible.
Second, I think my video has gone off. Can't see.
Right, maybe yeah, maybe because of weak internet signal.
Correct, correct.
Uh,
But I am
right,
audible, right?
you're audible right now.
Yeah,
Yeah.
I'll answer the question. It's a very good question, Pradeep ji. Yes, it is true that there is decision paralysis in the government body. Uh, the I would say that you are also correct that the decisions of the arbitrators or the arbitral tribunal is challenged by the authorities in the courts. But in our experience, what we have found is now the arbitral tribunals have started imposing costs on the parties, including the government bodies, for delaying the process. So therefore, I would not say there is a sea change, but there is definitely an improvement in terms of how much the timelines are being adhered to. Because if you would have seen in the case of DMRL, that is Delhi Metro, where Reliance also had an award, the award was carried up till the point of Supreme Court, and Supreme Court being now in favor of pro enforcement or pro arbitration, they have asked for payment of the amounts despite it being a government body. And the government bodies fail to realize that the interest part or the cost part keeps ticking from the date of the award, which is now statutorily fixed at 18%. So therefore, there is a marked improvement. But yes, as I said, there can be the the timelines could be improved better if the government bodies also are able to speed up their decision making process.
Okay, there's one more question. Is cause of action same as date of event of dispute?
Uh, ca- ca- Cause of action in law, as you know, is a bundle of facts. There, it cannot be one single date that can decide the cause of action. The date of event of dispute is the relevant factor. There may be certain other factors also. Sometimes contracts may dispute would have arisen, but the arbitration clause in the contract will also talk of a negotiation part whereby parties negotiate with each other. So that period where parties negotiate with each other under the contract gets excluded. So therefore, the date of event would the cause of action uh, and date of event are disjunctive. uh, Date of event is one of the reasons why the cause of action to claim the monies from the from the opposite party arises.
All right, great. There's one more question. There are questions, but I'm picking one of those. If an award is given by the tribunal to the claimant, in such case, is there a timeline for making payment by the respondent?
Uh,
This question is by
it
Mr.
totally
Srinivasa.
depends. Yeah, it totally depends on the terms of the award. If there is a timeline fixed by the award, that timeline would have to be adhered to. If not, when the tribute, suppose if it's a money award, a payment for money, the if a challenge is made before the court, the usual process is that the party who is challenging the award would have to deposit either 50% of the amount that is claimed, or at least give security for the entire award if he is not willing to pay the amount mentioned in the award. Either he deposits 50% of the award amount awarded by the tribunal, or he at least gives security for the amount, and that 50%, as and when it is deposited, can be withdrawn by the successful party in the arbitration. There's one question, Abhishek, which I would like to know. If award is passed beyond 12 months without there being any order permitting such extension, whether such award would render the award as void. Uh, it's a very good question, because Section 29A, which prescribes the time limit for the extension, if no extension is sought for, the uh, since it's a mandatory provision, I would want to argue that it has not been decided yet. I would want to argue that the award, if any, passed without an extension being procured, is a void award, and then it is an incurable defect in the sense that you would have to again repeat the process of arbitration.
There's one more question which was asked earlier. Uh, the question is challenge to award as per section 54 or 48 can only be set aside the award. Can the courts say the arbitral awards?
Yes, Pradeep is correct in saying that the section 34 and 48 are only to set aside the award. Under, if you see under section 34, in fact, it is section 36(2), which talks about stay of award. If you see section 36, I read it for your convenience, where an application to set aside the arbitral award has been filed under the under 34. The filing of the award application shall not itself render the award to be unenforceable unless court grants stay of the operation of the award. So therefore, the courts have to stay the award. Earlier, the regime was that mere challenge to the award would operate as stay of the award. Now, unless the court for sufficient reasons stays the award, it is deemed that the award is enforceable as a decree.
Okay, great. We are running out of time, but we can still take one more question, the last question.
Last of the question, what
Uh-huh.
if there is a disagreement on what exactly is the date of cause of action and the pre-arbitration? Who will be this, as you know, is a jurisdictional fact, and under section 16, if you want to argue that the cause of action has not arisen, that also would have to be decided by the arbitrator. If you say that the claim is time barred, you can raise that defense before the chief justice or the high court, or during the process of appointment of arbitrator also.
All right. So thank you, Mr. Hariharan. Thanks for taking up all these questions and giving them, and answering it for them, for the attendees here. Now, what I'll do here is that there's one last poll which I would like to conduct, and that is, to the attendees. And the question is, do you think creating contemporaneous record is the need of the day? So I'll start this poll, and the poll, as you can see, appears on your screen now. So we'll keep it open for about 30 seconds and see what attendees have to say on it. Thank you. Thanks for taking this poll. Now, now we'll move to our next panelist, Mr. Mr. P. Srinivasa Reddy, to give his presentation. We have allocated about 30 minutes of time for his presentation on expert evidence in arbitration. So, Mr. Srinivasa, it's all over to you. You can present your presentation. All the best.
Yeah, thank you, Abhishek, and hope it's visible, the
Yes,
presentation.
it is visible to us.
Yeah, good afternoon, esteemed engineers and legal professionals who are joining this webinar. And it's my privilege and pleasure to share some of my thoughts and, as a practitioner, some insights into this topic, which is very, very apt currently in this country, because we have seen uh, after in this 21st century how the government is giving a lot of emphasis on creating infrastructure. So subsequently, because these are big ticket projects and huge uh, learning is there in the initial stages, we had a lot of foreign inputs, both in engineering and also in policy making. This has created, I cannot say conflict, but some confusion among the stakeholders. So thereby, there is a bit of ambiguity that arises to some sort of issues which led to litigations or disputes, thereby claims were being put up between the parties or among the parties, and subsequently counterclaims were being kept. So that is where last 2 decades, both on engineering front, on management front, and also on policy making, plus framework and legislation. Also, there is a huge learning happened. So now the challenges are specific to the topic is arbitration with respect to infrastructure, and the topic given to me today to deliberate is expert evidences in arbitration. I thought, let me confine myself in this half an hour, pondering on certain points, taking up some, examining or looking at some larger issues, what's happening in the infrastructure or construction industry, how it is organized, what is the value system in it, and are the practices what we are adopting, is it right, because of which, or it is wrong, because of which these such huge disputes, litigations and claims are arising out, and what are the alternative opportunities to work to move the project faster, avoiding such type of legal litigations. And of course, looking into the topic of expert evidence, what is the legal framework we have as a Indian law or international arbitration? What is the way forward in case if we want to have ease of doing business, or we want to have a litigation free infrastructure sector? And this presentation, significance of the topic, of course, I just given an overview, and the keywords are arbitration, infrastructure, the challenges, evidence, and expert evidence. So I will try to decode to understand in a very simple jargon, not confusing with a lot of management and legal jargon. And of course, what is the position of law in this country with respect to this evidence and expert evidence with respect to arbitration, very specific to infrastructure projects, and of course the concepts and some guidelines let's see. Of course, now everyone is talking. We are all a cricket-friendly, cricket sportive country. So we have seen recently, not recently, maybe a decade or 2 decades back, third umpire is coming into the play for any decision to be taken where there is a complexity is involved, where the umpires in the field are unable to take a decision. So I thought this is very apt, and in fact this was being quoted very recently in Supreme Court also as a comment across the comment in a bench. So like in a cricket, you play by the rules. So obviously ours is a democratic country with a constitution in place, and ours is a rule of law. rules-driven businesses we are doing, not on an ad hoc or arbitrary basis. So if there is any dispute arises, the third empire steps in, who adjudicates the matter based on evidence, not on intrusion. Though it is a infrastructure is in engineering, earlier arbitrators used to be departmental higher-ups like chief engineer or director engineering, departmental heads, but we have done with it because this is a very, very highly specialized subject. Not only engineering, law background is also equally required because intrusion will not work. Someone has to appreciate, understand and appreciate the evidence what has been brought before him by the parties. So this is a game changer. Evidence is a game changer in arbitration, like in sports. So let's understand another word, infrastructure. Of course, this is a dictionary meaning. Infra means below, something is under, which is supporting, like a foundation. So for a country's economy, its people's progress, it is very essential we should have a basic infrastructure in place. That is how from 50th year of our independence, 1997 onwards, to till now, we have been giving a lot of emphasis on spending taxpayers' money, budget after budget, allocating to funds to infrastructure. Of course, this will happen from now 75th year to 100 years. The amount of money we will be spent is much more. And you can see infrastructure is a big within the construction. There are a lot of sub-sectors of infrastructure as per this notification. This is the latest notification. Probably I thought, let me share what are these subcategories, infrastructure subcategories. That is transport and logistics, in which we have roads, buildings, bridges, ports, shipyards, inland waters, airports, railways, and within railways we have other subsegments. Then you have logistics infrastructure, then urban public infrastructure like metro, then bulk material terminal pipelines. Then we have energy, both energy generation, transmission, distribution, and of course it is energy is based on hydro, thermal, nuclear, wind, then gas based, and we have one of the sectors is storage facilities for this gas, oil, like that, and water, both fresh drinking water and sanitation, dirty water also. So that is also part of infrastructure, in which you have irrigation, dams, canals, like that. Then communication systems, what we are using, the telecommunications. Now we have moved from 4G to 5G. Then there is a social infrastructure, social and commercial infrastructure like educational institutes, sports infrastructure, hospitals, then tourism infrastructure. Here it is a combination of both the public and public-private participation also. Then there is a common infrastructure like industrial parks. Then coming to ours is an agrarian country, though we moved from agrarian to manufacturing service sector, but still on the back end, being a 130-140 crore population, we need to store our food grains for next 2-3 years. So there is a huge back end supply chain infrastructure getting developed in terms of cold storages, warehouses, like that. Then coming to soil testing, because so much of money is being spent, so soil testing for construction activities and also for agricultural activities also. Then these are recently added affordable housing, and after pandemic, looking at there is a migration of workers, again reverse migration. People left towns, went to their villages. Then to bring them back, the policy makers decided that we want to have an affordable rental housing. In fact, I think today in the newspaper they have reported that 66 projects were being launched under this affordable rental housing, and the parliament committee which is looking into this, they wanted to have a status report. What is whether tenders were being invited, something like that. Then civil engineering, though it's a very complex subject associated with civilization, but to make it simple, there are fundamentally two challenges are there. One is to design, build durable structures. So design is one aspect, and another is execution, that is construction. Then second is, since we have been spending a lot of money on going on constructing new projects, new infrastructure facilities, but it needs to be repaired after 15-20 years. So there is another angle of civil engineering is maintain, repair, then extend the life of the existing structures. Like our human beings, once we reach certain age, we need to go to a doctor. So health care is required. Same case here also. This is concrete health care, health monitoring and condition survey of civil engineering structures has to be done. So in simple, one profession is related to predicting and preventing, that is during construction. Second is after in the execution in the existing structures is correcting the wrong. If there is anything went wrong, like structural deficiencies, erroneous designs, substandard materials, poor workmanship, inadequate supervision, non-compliance with technical standards, etc. These are some of the aspects where disputes or claims will arise, apart from money matters. These are technical issues where claims and counterclaims, litigation happen. So how do you cure these things? Of course, where there is a right, there is a remedy. That is what the position of law is. Then once you know the right, it is violated, you know the remedy, but how do you show that my right is violated and this is what is the claim I am supposed to get? This is where the evidence will come into the picture. So friends, I think it's not visible. Hope it is visible, this slide. This is how the industry value chain is all about. So otherwise, in the first step, when all people, all stakeholders come together, they come with a very, very open-minded, with a positive attitude to perform their role and responsibility in that project. Whether it is a developer, promoter, builder, it is engineering part, where they have a will and wish they express in the form of engineering language. Then the consent is given by the designer, consultant and architect, and they bring the technology to the project to implement it. And the choice is the contractor, subcontractor, the purchasing department to bring material, manpower, machinery into the project. That is management aspect. whether it is people management, material management, supply chain management, finance, accounting, things like that. Then comes is the facts, user requirements. Here is the legal framework. Like we have seen in infrastructure is subdivided into several categories. If it's a water, like an irrigation dam, user requirements are totally different. If it's a road, if it's a bridge, requirements are different. So like that, it's a combination. When you create a project, conceive and create a project, it's a part of engineering, technology, management. Of course, during the construction, in the very initial stage, as you are divergence to convergence, everyone will forget about the law of the land. They only look at the greener pastures. Hello, bhai, we will complete the project, no problem. With a very, very good positive attitude. And I like it as an engineer. Their disputes are not there in the initial stage because everyone wants to convert. They give their knowledge, complete the project, take the profits. So, but once the project is over or in the initial stages of execution, then there is a difference of opinion. Then comes is the evidence, as I said. In evidence, let's understand the expert evidence. In the first word is expert. Who is an expert? As per the dictionary, the simple meaning is a person who through education or experience, either education or experience or both, have developed skill and knowledge in a particular subject so that he can form an opinion that will assist the fact finder. This statement again brought another key word, a fact finder. Who is a fact finder? A fact finder is a person who searches impartially for the actualities of a situation. So here the fact finder is the arbitrator or a judge in a court. If it is an arbitration tribunal, it is an arbitrator. Probably the person whom we call as an expert, apart from education and experience, he would also have some understanding on policies making, policy research, and existing policy analysis, both engineering codes, codal provisions, as well as legal codes also, both substantive codes and procedural codes also. And he should be an expert, a specialist with vast, versatile experience in India. When we are talking about law of the land and the engineering practices, preferably he should have experience in India. Internationally fine, but there are codal provisions will be varying. Now today we follow Bureau of Indian Standards, whereas America ASTM, British standards, DIN standards, like that. Then key dispute resolution and litigations. Fine, we have converged all these people, stakeholders. They started their journey. Suddenly they found their rights were violated. Then they started dispute litigations and how to resolve these things. Yet keeping good relations among the stakeholders of the project. So again, I am still on the engineering point only. Here, 3 M's, which brings to the project. Apart from another 4th M is money, that is finance. So one is materials. As I said, there is a deficiency of material or inferior materials are being used, materials which are substandard, something like that. So you should have a thorough knowledge on material sciences. So that is one component. Then second is methodologies, that is engineering and technology, which is being brought by the designer or the architect that component into the project. And third is manpower, the contractor or the workmanship, the machinery which is engaged in the project to create that infrastructure. So 3 M's are there. And whose fault in these 3 M's? Unless there is a analysis, a forensic analysis, reverse engineering is being done to study whether there is a problem of the materials, design or construction, fault in the construction activities, or lack of supervision, some compromise in quality of construction, something like that. Then review the available evidence to arrive at a preliminary conclusion. So most of the cases they say when we associate with this, when there is a collapse in an ongoing project or where there is a problems, claims and counterclaims, the prima facie they say is a case of design and construction flaws. It's a simple blanket statement. You may see in the newspapers also, when there is a collapse, suddenly the expert will come from a research institute or an academic institute, and he blamed both designer and construction contractor. And there are cases where contractor was being kept behind bars. He was sent to jail, and murder cases were being booked on the construction companies. So in fact, the organizers headquarters in Kolkata, and where I am sitting and giving presentation, we had a link, IBRCL and their Kolkata flyover. So in 2013, I think, if I am able to recollect, it has fallen, two spans fallen. Suddenly, everything, it is so chaos. Then IVRCL directors are booked under murder case. Of course, after 3 months, 6 months down the line, when the charges were framed, they have been relieved from these murder cases. It is only purely negligence at the site, something like that. So the cases severity has been brought down. But by the time media trial has happened, the brand of the company and individual reputation is damaged, which is unrepairable. So like that, there is a huge problem in this today 24/7 main media and also in social media. So we have to be very cautious. So material evidence to be collected from site to examine before making a detailed conclusion. So prima facie conclusions are superficial and they cannot be taken granted. So we need to have a detailed analysis by experts so that they are undisputable conclusions in front of the arbitrator or in the eyes of the judge in a court. So like that. So ultimately, here the expert whom we call, and when he is interacting, when he is associating, he should have a knowledge on three M's, so that he will gather the required evidence to see that the facts are being brought in a fair and just manner. So now come to the second part, from engineering to the legal side. It's a plain English only. I don't want to create a confusion using legal jargon. So what is evidence? Every time we talk, even in our show me proof, show me evidence, or we will say you are making a baseless allegations on me. Even in a friendly conversation, somebody says you are like this, you are like that, then we will say no, you are making a baseless allegations. So evidence means to prove or disprove a fact or a statement. So evidence comes from evident. Evident means it should be easy, it should be crystal clear, removing the ambiguity. So whatever document or statement we are making as a evidence, it should remove the ambiguity rather than creating more confusion. So that is the first and foremost point to be kept in mind when we are seeking for evidence or an expert making a oral statement or a testimony. In Evidence Act, we have oral evidence, we have documentary evidence, and further these two are being categorized as direct, that is primary evidence, or indirect, which we call as a secondary evidence. In oral, we say hearsay. I am not there as a direct witness, but when I am going through that place, or it came to my notice, someone who is associated with that project during that time, he has told like this. So that is a hearsay. So hearsay probably will be useful to certain extent as a indirect and a secondary evidence. And there is another category of evidence is about the material, the object, what is in dispute or the issue. So that has to be brought in front of the tribunal in its physical form. So normally what happens is in disputes like civil engineering or infrastructure, so we are talking about an object which cannot be relocated, it is immobile. So here the evidence, for seeking the evidence, we can ask for an advocate commission or an engineer commission to look at that object and notice, record its characteristics and features. What is the with respect to the litigation issues. Then, of course, our Evidence Act talks about expert opinion, expert evidence, but that is more related to, it is a wide variety, not only confining to construction or infrastructure, but it is even for civil suits, then criminal cases like murder or such grievous cases also. Like you have fingerprints, probably I'll take you through those slides also, one or two slides. So ultimately, it is an exception. These section 45 to 51 are exceptions to call for the opinion of a third person who is not a direct witness to the that particular litigation or dispute or crime. And what are the conditions for, as per this Indian Evidence Act, is the dispute cannot be resolved without an expert opinion. If the court comes to a conclusion, or here in arbitration, if the tribunal cannot resolve, if they come to an opinion or a conclusion that we require an expert, otherwise miscarriage of justice will happen. Then the second thing is the witness expressing the opinion is really an expert. So there is a complexity of engineering issues. Drawings are there, calculations are there, codal provisions are there. So normally, of course, in arbitration, infrastructure arbitration, civil engineering background arbitrators will be hired by the parties, and through which the principal arbitrator will be retained. But if it is a court appointed or something like that, or engineering is a small part of a larger arbitration, or we have hired engineering background arbitrators, but to certain extent we require specialization on information technology or some sort of a financial background there, economist is required. So there his opinion is required. So to that extent, they can admit an expert opinion. So as per this, who is an expert? So this section 45 means expert means a person who has special knowledge, skill, or experience. Of course, as I said, this is mainly related to 5 aspects. One is foreign law, because most of the judges are trained in Indian law. So if there is any dispute among some sort of a stakeholder parties who are from different countries, something like that, then foreign law plays a role. Science, art. So probably here science means engineering and technology also. So handwriting, these are mainly related to some sort of forgery, the fraud and things like that. So here the person should have experience, knowledge either by practice or observation or by proper studies. So academic qualification, or he has vast knowledge through observations or through directly practicing that field. Same we can extend it to arbitration, more so construction arbitration also. And recently, to see that this country moves very fast on infrastructure segment, because certain contracts are non-enforceable, and even arbitration awards are being given. Regular courts are giving certain injunction orders. So keeping all this in view, and to overcome the inefficiencies in the Parent Act, an amendment has been done to this Special Relief Act, wherein they have brought a new section 14A about expert opinion. Means a 1963 Special Relief Act is been amended recently, about 3-4 years back, incorporating expert opinion. So what is the duty of an expert, and what is the value, to what extent we can give the value to that expert opinion, and how value will be established to that opinion. So first we have to understand is, an expert is not a witness. He need not be at the site or associate with that project to give a witness. And his advice is, his evidence is only an advice. Opinion is a statement, but it may be a true or may not be true. If it is true, then it is closer to the fact. An expert does not decide. He only gives his advice in the form of an opinion, either both testimony or in writing. An expert witness is to furnish the necessary scientific criteria. In engineering projects, he should give a criteria, broad guidelines, how to adjudicate the matter. Thereby, the judge to form his independent judgment by application of the criteria to the facts to prove the evidence. So these are 3 duties of the expert whom we are hiring, the parties are hiring, or the tribunal is hiring. And the value to the opinion comes from generating data and creating evidence out of it. Statistical evidence rather than empirical evidence. So today we are all talking about data analytics, data-driven economy. So opinion evidence, opinion to what extent? So if it is oral, so probably somebody will do a cross-examination and clarify if there is any confusion or ambiguity, something like that. But
So
otherwise,
Reddy-
if it is written opinion, it has to be very, very logic and reason to be built in that opinion.
Mr. Reddy, we have 5 more minutes.
Yeah, I'll complete it.
Thank
So
you.
the difference between evidence and an ordinary witness, expert evidence is being brought out in this slide. And if it is related to Information Technology Act, because we exchange a lot of information through emails, folders, and other today through our WhatsApp chats and things like that. So when we are all bringing that in an electronic form, then it has to be vetted by an expert. So always a physical document is better than an electronic document. Then admissibility of expert opinion. Expert is examined as a witness, traditionally in a court, so also in the tribunal. And expert gives reasons for forming the opinion. He has to give the reasons why I have come to this opinion, and what is the criteria, and what is the parameters driven to this one. And cross-examination by the adverse party, means opposite party is permitted. And the law that some scientific experts are required. So coming to arbitration, more or less it's like a court in India. But internationally, if you see, law of evidence is very crucial branch of law on which jurists rest. So more or less law related to evidence is same. Here terminology may change, like testimony, we call testimony evidence, documentary evidence, then physical evidence that is related to material or objects, then scientific evidence. Then scientific evidence to be demonstrated, it should be demonstrative evidence. Unlike oral testimony, then of course expert evidence has started way back in 1782, related to science. In matters of science, the reasoning of men of science can only be answered by men of science. So I believe infrastructure projects where engineering and technology is the input. So here science is also associated. So the expert evidence origin has started towards infrastructure litigation and dispute relationship way back 1782 onwards. Then of course expert evidence in arbitration. It is technically complex because construction disputes are technically complex and factually intensive, and very specific claims are being made sometimes, for which you require sophisticated methodologies and qualification in that particular field, whom we can use them as expert evidence, so that justice is being done. And expert evidence plays a crucial role. What happens sometimes, I have seen, just to save some few thousands or lakhs of rupees, people don't utilize this opportunity, parties don't utilize this opportunity, and this negligence will cost them huge by losing the case in front of a tribunal or in front of a court. And methods of presenting evidence, it is basically traditionally in India we are doing the same what we do in the regular courts, like examination in chief, cross-examination, re-examination. And nowadays in arbitration, to reduce the time, we are asking examination in chief to be filed in a form of an affidavit. But internationally, the party appointed experts, tribunal appointed experts, these are two are there, but mainly party appointed experts have been the preferred mode of presenting the evidence. Then of course the challenges are, there are huge criticism between these party appointed and tribunal appointed. So party appointed, obviously, like advocates, they favor their appointees, their parties. So it is partially correct and partially incorrect, and it is biased document. And it gives conflicting facts. So ultimately, engineering, here I am just telling a lighter vein, engineering is constructive, as I said, from diverse to convergence. Now the second step, when it is dispute, the same stakeholders will take a convergent view to divergent view. So it is a collapsive theory here. There is a constructive theory, here it is a collapsive theory. So thereby conflict of facts will come into play. Different type of data is being put forward, different methodology is brought out, and thereby the arbitrators get more confused. So these are some of the things, and it is a tribunal. This is more like a fourth umpire. You are bringing one more specialist, and it may lead to egos also. So missing multiple perspectives. So these are some of the criticism when you see in arbitrations. And what is alternative procedures? There is some thing which in conclusion I will tell rather than this entire thing because lack of time. Already I'm running short of. And coming to specific to our Arbitration Act, Section 26 deals with expert appointment. One or more experts to report on a specific issues. So this is mainly on specific issues. If the parties agrees, first the parties should agree, and subsequently the tribunal should also give concurrence, so that then the experts, one or more, can be brought in. Then
Mr.
coming
Reddy?
to, yeah, I'll conclude it in another minute.
Can we come to the conclusion?
Section 27 talks about court assistance taking. This is like the civil suits only, where tribunal feels an evidence is to be seeked, then that either a party with the permission of the tribunal, they have to approach the civil court of the jurisdiction, so that the court will send summons to those people, those witnesses, to come and give the evidence in the tribunal. Then, as I said, what is the proposed solution and best practices? Appoint party appointed experts. These experts to be accessed means and the arrangement in case if the experts are appointed by the tribunal, so the parties experts should be given access to the documents prepared by them. And of course, the Supreme Court, what is the stand on expert evidence? So it says that in conclusion, expert should give reasoning along with the basis of his opinion. A mere assertion is not sufficient. So there are conflicting opinions on it, and ultimately it says that the expert opinion should be in writing, giving logic and reason, rather than just making a statement, how big he may be in that field. Then what are the challenges? In conclusion, is one is the most important is to expert witness is an opportunity for the arbitrator to ask questions and know from the expert the business processes, business practices, and the technical details. If you see, I am just quoting out of the way, but here, since I come from Hyderabad, when the Satyam scam has happened, it was very difficult to understand the investigator, CBI or something like that, or ED, because it is a totally different businesses, different practices, and different technical jargon they were using. So to decode it, again they brought domain experts into that one to understand it. So then second is the biggest challenge today arbitrators faced is, by bringing so many experts, are they able to find out the truth from the expert reports? And are they missing any opportunity to do cross-examination by filing written statements, written expert opinion documentations? So this needs to be seen, and ultimately it is a good opportunity for arbitrators to understand and formulate their own opinion, how complex it may be, by going through these voluminous documents or this one. Then justice is ensured to the parties. So, of course, again, concluding part is that in the initial stages, if we follow some of the golden guidelines, then handling a project without any legal litigation is possible. So, some amount of expertise, legal awareness is required in engineering and construction companies which are taking up infrastructure projects. So with this, I conclude my presentation, and thank you very much. I think I've jumped about 10 to 15 minutes. Yeah, the session is open for Q&A.
Yeah, thank you, Mr. Reddy. So now I would like to ask our attendees if they have any questions that they would like to ask Mr. Reddy. You can put your questions in Q&A section, and that will be answered by Mr. Reddy. So if you have any questions, you can put it right now. All right. Anybody wants to raise his hand? Okay, I guess there's one question. What is the difference in expert witnessing between common law and civil law, sir? I think that's what the person, it is by Mr. Ram. What is the difference in expert witnessing between common law and civil law?
Means it depends. See, in arbitration, actually, whom I am audible.
You are audible.
Yeah. In arbitration, the tribunal has the freedom and flexibility to choose the procedures, irrespective of the law of the land, like even Evidence Act, or codal provisions like the Code of Civil Code. These two may or may not be considered. So it is up to the arbitrators or the parties. It depends upon the agreement between them in the very initial stages. Accordingly, the procedures will be recorded, and then that's how the proceedings, arbitration proceedings will take place. And applicability, coming to my experience in India, is very simple, because the parties wants to not to go into such a legal procedures. So they want to have a win-win, and they want to continue their working relationships. So they will not be very rigid. So they will leave it to the comfortability of the tribunal to follow the and adopt the rules and regulations.
Thank you, Mr. Reddy. Now, all right. So now there's one more question. We'll have a very brief answer for this question. It is by Mr. Pradeep Moksh Gundam. His question is, for a tribunal appointed expert witness, who bears the cost and how the fees is decided?
If it is a tribunal appointed expert, means the cost has to be paid equally among the parties. If it is 2 between the parties or among the parties, more than 2.
And we'll take just one more question, and with a very precise and short, simple, crisp answer to it. It's the question is posted by Mr. Jaideep Ghosh. It's is oral evidence is a must in arbitration, or arbitrator may free to not opt this option?
The oral evidence is a must. Is if the party feels that is the requirement, and even if the arbitrator is giving the permission, assume he has put up a memo to the tribunal and the tribunal denies it, fine, you can continue with the proceedings. But when you are if the arbitration award, final award is favorable to you, no problem. If it is against you, you can raise this one, and the probably the tribunal will make a record why this memo is rejected. So you can challenge, you can raise this fact of denial of the witness when challenging the tribunal award.
Thanks for your answer, Mr. Reddy. Thanks for answering the question posted by the attendees here. Now, what we'll do is that we'll quickly start a poll. We have just 30 seconds to answer this poll, and the answer and the question is, I'll post it on the screen. So the poll starts now. So we've got 30 seconds to answer this question. Let's see what our attendees have have in their mind. So the question is contract management quintessential for a successful arbitration award? Okay, so again, 100% of our attendees agree that it is very important to maintain contemporaneous record is the need of the day. So now I would like to thank Mr. P. Srinivasa Reddy and Mr. Srikanth Hariharan for their valuable insight into arbitration, especially in infrastructure domain. I think your experience and your ideas about arbitration definitely must have helped our attendees here, and they would definitely return back to home with much better idea about how to how to walk the path when it comes to arbitration in infrastructure industry, and why timeline is so important, and what is the importance of expert evidence in arbitration. So I would really like to thank both of the panelists for giving their valuable time and helping our attendees with their questions. Now before we log off, I would like to thank all of the attendees for attending this session, and I'm pretty sure this session would have added some value to your knowledge base. And before we log off, I would like to let you know that when we finish this session, all the panelists will be redirected to the website of Contract Square, Contact Us page. If you have any questions, just fill up the form and drop in your contact numbers, and somebody from my team will definitely contact you and help you with your queries with regards to contract management or arbitration. So thank you. So thank you, panelists. Thanks for your time.
Thank you, Abhishek. Thank you, Abhishek, for organizing, and Contract Square for giving us this opportunity.
Yeah.
Have a great weekend.
Our pleasure. Thanks.
Great weekend. Thank you very much.
Thank you, Mr. Reddy.
Yeah.
Definitely.
See you, Srikanth.
All right.
Sure. Thank you.
All right.